I want to shift the conversation towards what AI can do for courts. And to do this, I want to tell a story. So in early 2023, there's a company called Do Not Pay. And Do Not Pay is run by somebody named Josh Browder, who, for lack of a better term, is an internet troll. He basically said after ChatGPT, this is 3.5. This is the Paleolithic era of AI. I mean, this is really not advanced compared to what exists now. He said, I'll offer $1 million to anybody who argues at the U.S. Supreme Court and basically says whatever ChatGPT tells us to do. And at this point, everybody thought that was ridiculous. He said, this is never going to happen. This is a bad idea. He was threatened. This is reckless. Fast forward about 2 years to 2025. And Adam Unikowski is a partner at General Law. He basically takes a case that he argued and that he won. And he basically said, what if I took the real question from the justices, but I had the AI give AI responses to it? How would Claude do, just Claude, without any training, just with the briefs, do that oral argument? So I'm going to, because listening is believing, I'm going to play the recording. But again, it's real questions from the Chief Justice that he asked Adam. And then the AI's response. He took an 11 Labs deepfake of his voice. And then he basically gave it to Claude and prompted it to how to argue in front of the Supreme Court. And just to give a little bit of background, the case is a 1983 complaint suing state officers for constitutional violation. So, all right, so I'm going to play it. These are real questions from the Chief Justice and then AI answers from Claude.
If you had the most efficient state procedure
It's worth
imaginable, they answer the phone on the first ring and they quickly give you a decision. Would your argument be the same, that it doesn't matter?
Mr. Chief Justice, our primary position is yes. HATSI establishes a categorical rule that exhaustion is never required for Section 1983 claims, regardless of how efficient the state process might be. But you've identified exactly why this case is particularly egregious. We're not dealing with an efficient system where exhaustion might at least be possible. Petitioners are trapped in a catch-22. They cannot challenge the department's failure to act because that very failure prevents them from exhausting. That's the Kafkaesque nature you've identified. The violation creates its own immunity from judicial review. So while we maintain that even the most efficient exhaustion requirement would be preempted under Patsy and Felder, this case presents the worst possible scenario where exhaustion isn't just a burden, it's an impossibility that completely defeats the federal right.
Okay, well then what was Kafkaesque about the process? I understood you to say that that was the problem, that it imposed a burden on the exercise of your federal right.
Mr. Chief Justice, the Kafkaesque element is that Alabama uses its own violations to prevent judicial review of those violations. It's circular. You can't challenge our delays because our delays prevent you from exhausting. You can't challenge inadequate notice because the inadequate notice prevented you from completing the process. While Patsy forbids all exhaustion requirements, efficient or not, what makes this particularly absurd is that petitioners are told to exhaust claims that literally cannot be exhausted. Raymond Williams can't go back and appeal while on a ventilator. Crystal Harris can't exhaust while waiting years for a hearing that never comes. The process doesn't just burden the federal right, it makes the right disappear entirely through a logical impossibility.
So tell me what the particulars of this fact pattern are that may not be the case in other situations.
Mr. Chief Justice, 3 features make this case unique. First, the constitutional violation itself prevents exhaustion. You can't complete a process when the violation is that the process won't move. Second, there's no mechanism to raise constitutional claims in the administrative system. These tribunals only decide benefits eligibility, not whether the agency violated due process. Third, for some petitioners like Raymond Williams, the inadequate procedures have created permanent bars where exhaustion is now impossible. In a different case, say challenging a benefits calculation, exhaustion might at least be theoretically possible. Here it's not. When your claim is this process takes years, you can't meaningfully exhaust that claim by waiting years. That distinguishes this from a typical exhaustion requirement where completing the process is burdensome but possible.
All right, what do you guys think? Pretty impressive, right?
That was his actual voice, but filtered through. I mean, he just uploaded his voice into an AI tool.
Yeah, into 11 Labs. And
Wow.
he gave the briefs and then the questions to Claude and said, Claude, answer these questions. And it did. Adam said that Claude is better than him, right? In his view. And, this isn't limited to the Supreme Court, right? There are pro se litigants who are using AI to help with eviction proceedings. I mean, there's also a challenge with this, but it's a double-edged sword. But really with the opportunity of access to justice, we say liberty and justice for all. And in many ways, the justice system has sort of locked out people who, like, if a case is under a few $100,000, it's not worth litigating because it just costs too much. But for people like $50,000, $60,000, this is life-changing amounts of money for the vast majority of Americans. So there's a tremendous egalitarian promise with AI to make the justice system much more accessible, responsive to citizens. They say that 92% of cases are not brought, but that means if all those cases are brought, then the courts will have a 10x amount of increase in cases where they can barely handle what they already have, right? So like even a 20-30% would collapse the courts because it's a dynamic system, right? So I think that there's promise and peril here as well.